All right, so today's date scheduled for a motion hearing. The defense filed a motion to set aside the plea from 2019. Have the people filed a response?
Your Honor, we plan on just making an oral response.
And Your Honor, I would object to that. Specifically in my motion, I asked for an answer by the prosecutor. It was incumbent upon me to file a written motion, which I kindly served personally on the prosecutor. I told him at the time, I'll see your answer. My client wants to review it. He says, I'm gonna make an oral motion. I said, I don't want that. I want a written response. So,
Mr. Muhammad, why is there not a written response filed?
Because I would like to respond orally. I don't think a written motion is required, but if the court requests one, I will do that, but defense will not inform you like how to respond. That doesn't make sense.
Well, okay, just a moment, because the motion practice says that unless there is a request to waive a written response, then a written response is required for motions. Let me just,
that's what I'm relying on. I was in the court rule.
2.119. An application to the court for an order of pending action must be made by motion. Motion must be in writing, unless made during a hearing or trial. Motion must be in writing, state with particularity the grounds and authority on which it is heard, based. State the relief or order sought, be signed by the party or attorney as provided in MCL 1.109. A motion or response to a motion that presents an issue of law must be accompanied by a brief citing the authority on which it is based and must comply with the provisions of MCR 7.215C. Except as permitted by the court, the combined length of the motion and brief tells you about how long it can be.
Well, Your Honor, there's insufficient evidence for me to provide a very strong response. The reality of this case is many years old. We have no case in our system that reflects anything about this case.
Okay, just a moment, counsel.
Your Honor, the other interpretation is,
Just a moment, please.
let me know when I can speak.
Time for service and filing of motions and responses, unless a different period is set by these rules or by the court for good cause, a written motion. Notice of the hearing on the motion and any supporting brief or affidavits must be served as follows: at least 9 days before the time set for hearing if served by first class mail, 7 days if served personally or pursuant to MCR 2.107C1 or 2 or MCR 1.109G6A. And then sub 2, unless a different period is set by these rules or the court for good cause, response to a motion required or permitted by these rules must be served as follows: at least 5 days or 7 days, 3 days, whichever, those are within the appropriate ones. Mr. Serrano,
Yes, sir.
you made a statement in your motion. You made an allegation within your motion that there was an error in the acceptance of the plea. Did you attach a copy of the transcript so I can review where that error occurred?
Well, Your Honor, in answer to that, I did allude to the fact that we do not have a benefit of the transcript. In fact, while this matter was pending, I did email to your court reporter on this Bayhoot, I believe it is. I asked, is it possible to get a transcript from a case 6 years old? And she replied to me and said, yes, it is possible. So if the court is going to grant my motion, then yes, I would ask for a transcript.
So I can't even make a determination on that specifically because you're alleging that the plea was defective.
In the alternative.
And so if I can't determine if the plea is defective, if I don't have a transcript by which to look at.
That's not the only reason that I asked for the plea to be set aside, Your Honor. I also said, to answer your question specifically, if the plea is defective, then the court rule says the court must set aside the plea. So, and naturally, we would need the benefit of the transcript to see how the plea was taken. I spoke to Mr. Camilleri, his private lawyer, my client's prior lawyer. He came in personally and he said, basically this is what I know about the case. But I'm saying in twofold, in the interest of justice, in the first part of the court rule in 6.3110 says in the interest of justice, it should be set aside. My strongest argument, Your Honor, I believe is that there's been no contact with the victim. at the pretrial, that the court determined later this was not supposed to be a pretrial.
Well, hold on. When did I determine that this was not supposed to be a pretrial?
Well, Your Honor, when we had it adjourned for the prosecutor to subpoena the complaint.
So, Your Honor, may I please shed some light on this case? So initially, what happened at the last hearing, even the hearing before that, I received the case file, and on the docket, it reflected it as a pretrial. At that time, defense counsel discussed the case where, he brought to my attention, this case is from 2019. At that point, it's standard for us to set it for another hearing where I would subpoena the complaining witness to see if they appear. Because it's such an old case. I did that, and at that hearing, the last hearing we had, the complaining witness failed to appear. At that time, it was under the impression the case was going to get dismissed. However, the court brought it to my attention that the court had made a mistake by setting it for a pretrial to begin with. And they brought to my attention, which I did not have the information of, because it's not in our notes, was that the defendant had actually entered into a plea in this case, and then through his defense counsel, made a motion to withdraw the plea, and then absconded for many years. So then at that point, that information was brought to my attention. So we would object to the defendant withdrawing the plea. They had entered into the plea, and then to make a motion and then just disappear for a number of years, I think 6 or 7 years, they're essentially waiving that. And we are prejudiced. And we're prejudiced because it's clear at the previous hearing, the complaining witness failed to appear. So we're unable to make contact with that individual and understand her concerns, if any. However, what I do have is in our internal case notes, we have notes from the year of 2019, which indicates that she wants to press charges, wants no contact, wants the defendant in therapy, and then it says comma, bumps on her head and bruises on arm, and then it indicates defendant has a drug problem. It also indicates that 769.4A was explained, and that's the end of the note, and that was by the victim advocate. So we're prejudiced because at this point, we can't make contact with her. So to make a withdrawal to the motion, to the entrance of the plea, and then now say 7 years later, I want a trial when the victim can't be located, that's unfair, that's not right, and that's not proper. I think this is common sense, which is why I didn't think that a written motion is necessary to be written. I think it orally could be explained, and I think I've done that. And again, I would object to the court allowing defense to withdraw that previous plea, because I think it's unfair and it prejudices the people.
Okay, so just for future reference, counsel, if there's a written motion, there needs to be a written response. Just for future reference, that's what needs to happen. The court counsel is going to state this, that where I was having trouble following part of the motion, Mr. Serrano, that you had indicated,
Was this Mr. Camilleri's motion that I've incorporated or my?
I don't know, but I'm not sure why. Well, here's what I don't understand. You have a motion and
Right,
it says filed by defendant's former MIDC attorney Ken Camilleri is attached and is incorporated as if fully stated herein. And I'm going to state, there are not any page numbers on the motion, and then it just starts with the number 8.
right.
So that, counsel,
Oh, I'm just saying correct.
yes, but it should start with number 1, because this is your motion. This is your motion that you filed on behalf of your client. And so I thought maybe somewhere something was missing because it starts with 8, 9, 10, 11, 12, 13, 14, as opposed to 1, 2, 3, 4. And so some of this I don't even know because it's old and I'm not sure what this is even referencing. What I will state, so this is your motion that you filed,
Right.
and then you attached the prior attorney's motion, which is not even relevant either because that attorney had previously filed a motion. And if you're submitting a motion, counsel, you submit your motion, not the motion of another attorney. Further, this matter, as I stated on July 31st, indicated it was on the docket for a pretrial, but looking into it further, it should not have been scheduled for a pretrial. And in fact, somewhere along the line, your client must have either walked in on the warrant and paid a bond, or was in custody and received a pretrial date. I'm not sure how that goes. I think that you walked in. Did you walk in and pay a bond, sir?
Yes, Your Honor, if I
You
can
did.
speak,
No, not yet.
sorry.
And so when you walked in and paid the bond, that has been in effect since June 20th of 2019 because you failed to appear at your sentencing. So procedurally, April 9th of 19, Mr. Mulholland was arraigned. And then a pretrial was scheduled for April 17th. On April 17th, the pretrial was held and adjourned on May 2nd, all of 2019. May 2nd of 2019, a pretrial was held, at which time your client entered into a plea. Sentencing was scheduled for June 4th. June 4th, the sentencing was not held because the defendant wishes to withdraw the plea. NYDC Attorney Camilleri was to remain with the case, file a written motion. Motion hearing was scheduled for June 20th. June 20th, Mr. Mulholland did not appear. Did not appear ever until June 2nd of 2025. So I am going to state, the court does not, and then when you were arraigned on the warrant, it was erroneously scheduled for a pretrial. It should have been scheduled for sentencing. You've already pled. So when the sitting judge that was here on my behalf on July 17th, he set it for final pretrial. Again, that was not proper because in looking at this case, you have already pled guilty. So, counsel, the court's going to also state that I don't find any basis. I don't have a transcript in front of me. I don't have any reason why this court should set aside a plea 6 years later that would significantly prejudice the people. Because those are factors this court has to take into consideration in whether or not this court should grant the motion. And you and your client have the burden of proof to show that people would not be prejudiced.
May I respond?
Sure.
First of all, Your Honor, my motion begins with paragraph 8 because Mr. Camilleri's motion contains 1 through 7. I've incorporated that motion into mine, which is allowed in the court rules. It was allowed specifically by Mr. Camilleri. That's why I put with his consent. It was allowed by my client. These are the exact things that I would have said in my own motion. So I incorporated it because the court already had it. So and I thought it would be easier for the prosecutor to respond. He clearly stated last time we were here, yeah, we were going to be prejudiced. Never stated why. Because he's had no contact with the alleged victim.
It's been 6 years, counsel. 6
Your Honor,
years.
Why would I ask for to subpoena a victim if not to dismiss the case if she doesn't appear?
Counsel. Whether she was requested to be subpoenaed in 2025 is irrelevant. Your client had already pled in 2019. Just because counsel did not review the ROA or did not review the file to see that there was already a plea of guilty, there's no reason that there should even been any discussion regarding subpoenaing the victim. Now, in addition to that, there is no reason why she would have needed to be subpoenaed in 2025. Because this plea was entered in 2019.
The prosecutor agreed to subpoena. It wasn't my idea. It was his.
Counsel,
Subpoena.
clearly nobody read the ROA. Nobody read the ROA to see that there was a plea taken May 2nd of 2019.
Was it under advisement, Your Honor? Because I didn't see anything about a 769-4A plea. Usually the court writes it in the ROA. I reviewed it. It just says plea of guilty. A lot of mistakes seem to be made in this situation.
Well, counsel, I don't have a transcript to review to see if there were mistakes made.
Procedurally, under procedural due process and substantive due process, my client's rights have been violated because people have been allowed to make mistakes, be it clerks or otherwise, and a sitting judge is allowed to make a mistake, but my client is not allowed to make a mistake by not appearing at his motion hearing, which was a legal matter that he thought his attorney was going to argue in court with his other.
Let me clarify, May 2nd, 2019, the same date that the plea was entered. Nothing is on here about 769.48 on the plea form.
Okay.
So that's why there's nothing in here on the ROA.
So it's a straight on plea.
It says sentence agreement, no jail time, probation 12 months, anger management, drug counseling, no objection to removal of GPS tether, no contact with complaining witness. That is what it says on here. On May 2nd.
Which is superfluous because no prosecutor on a misdemeanor case can make any sentence recommendations that's gonna be binding. This isn't a felony with sentence agreements. That stuff shouldn't have even been on the form.
So whether it was on the form or not, I couldn't even get to the sentencing portion of it because your client failed to appear.
Because it was a motion hearing.
Okay, and then he never showed back up.
Why would he have to show up for a motion hearing that's gonna be non-dispositive on that date, Your Honor?
Because if the allegation is that there is an error or whatever it may be in the proceedings, right? And that the plea was not knowingly, voluntarily made, then clearly there needs to be a direct examination of your client at that motion hearing. So that is exactly why he would have been required to be present.
Mr. Camilleri did state, my client admitting only to, quote, an altercation. The words are allowed to give their common meaning.
Counsel,
Altercation means.
I don't have a transcript. I don't have a transcript by which to see whether or not the plea was erroneously made or
Then
not.
let us get it now, Your Honor. No, there's no prejudice to the people in that, certainly. Let us at least have the transcript to see what, if the court took the plea properly.
Well, counsel, you filed this motion, you submitted it without having a copy of the transcript. You made an allegation,
I don't even know if a transcript was available.
you made an allegation that the plea was taken erroneously, that there were errors made in the plea process. But you don't have a transcript by which that you've reviewed to make that allegation. You're going based on hearsay from everybody else because you were not the attorney of record.
And also the prosecutor read from notes that are hearsay, from his internal notes, from his, who knows who put those.
Let's say what?
He read you notes from his supervisor or whatever,
That
just
doesn't-
into the record.
But that doesn't have anything to do with the plea and how, and your statement in the motion is that there is an erroneous plea, that there is an error in the plea. You've made that statement, but there's not a copy of the transcript by which to support that statement.
Because I didn't know if it was still available. That's what I'm saying. If you allow us to get the transcript, then we can see how the plea was taken. Now that I know that it's available, I certainly would have attached it if I knew it was available 6 years later. But apparently, Your Honor, my client, is here today. And I do point out a thing that is very relevant. The same victim brought a charge of leaving the scene of a property damage accident with my client.
I'm
as
going
the
to
defendant.
object because I don't see how that's relevant.
It is certainly relevant.
No, it's not.
Because that's not even about this case.
It's the fact that she didn't appear and that one was dismissed very recently against my client. So I'm saying,
Counsel, if that's a recent case, that's a recent case. This is a 2019 case.
okay, how have the people been prejudiced? They haven't had contact with the victim. They represent the victim for prejudice purposes, not the Wayne County Prosecutor's Office. It's the victim.
We are prejudiced because if the court allows you to withdraw your motion and then you request for a trial, now 6 years later, we're unable to make contact with the victim to move forward with our case. Clearly, based on the notes, we did have contact with her 6 years ago. We're not going to set a precedent where a defendant.
You don't need to shake your head.
Oh, yes.
We're not going to set a precedent where a defendant can enter into a plead guilty and then make a request to withdraw and then disappear for 7 years and then come back and see if the victim's gonna appear to move forward. That's prejudicing the people and we're objecting to that.
I object to having no written response to give my client, like I gave him a copy of my motion to see what he agrees with and disagrees with by the people. It seems to me the court is saying, okay, that's okay, errors in the transcript, errors in the ROA, that's okay. Client not showing up, that's not okay.
And I think it's
Hold
improper.
on, pause. Counsel, at no point did I say errors in the ROA is okay.
Well, you're allowing them to be, this should have been this and should have been that when the ROA differs.
Counsel, I don't think that you're following what I said. Both have an opportunity to view the file. Neither one of you on July 17th, when this matter is up for it was set on the docket for a pretrial, okay? That should not have been done. That was a clerical error as why it was set for a pretrial. It should have been set for sentencing. However, your client had not been sent back for another PSI or otherwise, because obviously in 6 years, there's going to be some changes. But neither one of you looked up at the top of the second page that says pretrial held plea on May 2nd of 2019. So I'm not saying that there were errors made in the register of actions that that's okay.
No.
What I'm stating is that there was a clerical error that was set on the docket for a pretrial. However, it's incumbent upon counsel to look at the files to see what is going on with the file. Because it should have actually been set for a review, in my opinion, it should have been set for a review to determine what was going on, because Mr. Mulholland would have had to go back for the PSI and the sentencing date, but he would have for sure have had a PSI interview. And then the visiting judge that was here held it as a pretrial and set it for a final pretrial. At the end of the day, your client already entered into a plea May 2nd of 2019. And I have not heard anything. I don't have any evidence before the court. I have not heard anything that this court that would support the motion to set the plea aside or to withdraw the plea and to then start over.
Both in the interest of justice and the fact that it may have been taken erroneously, which I don't have a transcript that we can produce now that I know that.
Counsel, I'm not sure what interest of justice would be served at this point, 6 years later in withdrawing the plea. And I also am unsure as to what the erroneous procedures are when you yourself haven't reviewed the transcript.
Exactly.
You put forth errors in the
I
transcript.
did not say emphatically there were errors. I'm just saying the court rule says if there are errors in the plea taking process, then the court must set aside the plea. I don't know that. I'm not accusing this court of taking an erroneous plea. At this point, I'm saying I don't know. The benefit of having the victim here, Your Honor, even if my client is a spit of sentencing. Sometimes, I'm sure this court has heard it before, husband and wife come in and they say they want to kiss and make up. Maybe the alleged victim would have had something good to say about my client, and yet he's being deprived of that.
He didn't show up. He failed to appear. He failed to appear and didn't even come back at all.
Justice is
And-
deprived, Your Honor, for
Excuse
6
me,
years.
I was not done yet. And in fact, your client could have contacted his attorney. That was the attorney at the time. Did not do that, did not come even into this court until June of 2025. So I don't find any basis to set this, to allow this motion to be granted. And counsel, you filed the motion. So prior to filing the motion, if you want to allege there's an error in the plea process, then you should have had a copy of the transcript before you even filed the motion.
May I respond to that, Your Honor? Because I'll tell you why. I was given this case, then I was told you cannot appear at all on this case by the DLS office in Dearborn. So it went back to Mr. Shemke, who was scheduled for this day. So in the interim time, I emailed Mr. Shemke saying, this is what's gonna happen, you gotta file a motion to do this and that, the client wants to proceed. Then he asked me to stand in for him, and lo and behold, it's on this date. So I had barely time to file the motion, time, which I did. And I didn't have time to get a transcript, nor did I know that existed. But the court should able to reach farther in the interest of justice, saying, well, you know what? It's 6 years ago, maybe we should have the transcript now to see if there was an error in the proceedings.
All right, Mr. Mohammed, now you may respond.
Your Honor, I was just trying to highlight for the court that I think if anyone's deprived of justice, it would be the people, because the defendant failed to appear for 6 years at a minimum. We likely may have not even objected to the withdrawal of the plea at that time. However, to wait that many years and for us to know with certainty at this point that we are unable to make contact with the complaining witness, I think it's very inappropriate and unfair. I think this would be a horrible thing to set as precedent, where an individual would make a motion to withdraw a plea and come as many years later as they want. And then for us to not be able to move forward, I think would be horrible for the justice system. And so for the interest of justice, I would request that the court decline the defense's request to allow the defendant to withdraw their plea. If they had done that, I think the presumption is that a court would make sure that a defendant would enter voluntarily into a plea. And I think it's the defense's burden to show otherwise, and they have not done that. And so I'm requesting for the court to deny defense's motion.
And Your Honor,
Pursuant to the court rule, it is the defense,
it is my burden, I agree, but it's also incumbent upon the prosecutor to file a written response, which he's been given the permission to argue orally.
Yes, counsel, however, even if this court did not allow an oral response by the people. This court, in reviewing your motion and in reviewing the court rules and the case law, your motion has not, you have not met your burden to set this aside, and the court is extremely concerned that this would show, it's a very slippery slope on a precedent regarding precedents in doing this, especially knowing that the people could not get a hold of the plaintiff, the victim, because there was an erroneous understanding that this was set for a pretrial. So now knowing that there can't be contact with the victim, now this motion is brought forth, and the court finds that the people are significantly prejudiced, and that this is not in the best interest of justice, and the defense has not met to withdraw the plea, so the court's going to deny the motion.
What's gonna happen, Your Honor, at sentencing? The prosecutor has to notice the victim to appear and her victim's rights. The court is very, very cognizant and always paying attention to victims' rights. So now, if my client is appear at sentencing on a plea that is questionable by my motion, how does he have the benefit of the hearing what the victim says and respond? Because there's gonna be no victim.
Counsel, the Victims' Rights Act gives the victim an opportunity to be present. It doesn't require them to be present. If they choose not to be present at sentencing, that's their choice. I conduct sentencings all the time where the victims aren't present,
I agree.
but we send notice to the victim so they have the opportunity, which is what the act calls for. So whether the victim's present or not at the sentencing doesn't have any bearing as to whether this court should grant the motion to withdraw the plea.
But it certainly would have a bearing on the upcoming sentence, Your Honor.
In your honor,
No, I don't see how that's,
What the victim says at sentencing does not affect the court sentencing?
counsel, I didn't say it doesn't affect the court sentencing. The court takes victim statements into account when assessing the conditions or the sentencing that it's going to put forth. What I'm stating is that the Victims' Rights Act gives the victim an opportunity to be heard, if they want that opportunity to be heard. They don't have to avail themselves of that opportunity. And if they don't, then the court will fashion the sentence it needs to fashion. I do that on a regular basis. Victims are often not in court on the date of sentencing. The court still conducts the sentencing accordingly. So whether the victim is present for sentencing or not will not prevent this court from continuing with the sentencing.
in your honor, if I may, just for the record, there was a potential plea discussed with the victim, and it's my understanding that the victim in this case wanted no contact therapy, and there was a explanation in regards to a potential plea. So she was advised of a potential plea in this case, and clearly there was a request at that time. So the attempts by our office were met, but again, this was in 2019, and due to the defendant's failure to appear for multiple years, we're unable to make contact with her at this time. Thank you.
Your Honor, again, relying on hearsay of notes, I don't know that these things are true.
Okay, what I'm saying is that I've already ruled the motion's denied, so you need to go back, sir, to to get your sentencing, your PSI date and your sentencing date.
He's gonna have a new pre-sentence interview, Your Honor, and then come back with a sentencing date.
He has to, because.
The court agrees it was not,
presumably, I'm sorry?
does the court agree it was a straight up plea, is that right? No plea under advisement,
Correct.
769-48, right?
Correct.
Okay, then I'm gonna make the oral motion now that it should have been taken pursuant to.
I don't know what it should have done or should have been, counsel.
I think I can make that motion now, Your Honor.
Everything was signed by attorney and your client. And in fact, let me see here.
Well, then I'm making that motion now, Your Honor, that should be taken under
Well, counsel,
769-48.
I will, we'll set this for a Thursday, and, this court, will hear arguments on that date. I'm not going to entertain that today.
I'm not filing anything written, I'm gonna respond orally.
Well, would it be a response at that point? It would just be you raising an argument.
I didn't ask you, counsel.
Listen, I'm not going back and forth. I've already ruled on my motion. Go back, sir, get your dates for your sentencing and your PSI And then council, we will see everybody back on the sentencing date. Bond and conditions are continued.
All right, thank you, Your Honor.
Sorry,
Sorry about, sir.